Welcome to Chapter 3 of this module, where we will discuss case studies that are select on the right to health. Now, since the advent of the 2010 Constitution, the Kenyan courts have decided numerous cases on the right to health. Key among the issues that have been decided and deliberated by the Kenyan courts on the right to health include access to generic medication, the role of TB and isolation of patients, access to contraception, as well as the access to dialysis. One of the leading cases that has been deliberated on is the PAO versus the Attorney General case of 2010. This case was the first to be decided on using the Kenyan Constitution of 2010. The case constituted a constitutional challenge of Sections 2, 32, and 34 of the Anti-Counterfeit Act. The petitioners in this case, PAO and others, challenged the wide definition of counterfeit medicines as constituted in Section 2. Their argument was that if read and interpreted, Section 2 definition of counterfeit medicines would actually include generic medication. The fear by the petitioners in this case was that due to the fact that they were living with HIV, a wide interpretation of Section 2 of that act meant that there was a possibility of the police exercising their powers and confiscating their ARVs. This case is celebrated as one of the leading cases to be decided on what constitutes the right to health. Indeed, this case forms an important decision for doctors to be aware of. This is because the courts in this case challenged and agreed with the petitioners that Section 2 was quite wide and therefore could hamper the right to health. It is also important for doctors to note that in making this decision, Justice Mumbingugi, who was the judge in this case, acknowledged the inextricable interlinkage between the right to health, the right to life, and human dignity. This interlinkage between the right to health, right to life, and human dignity is important for doctors to remain aware of. Other cases that have recently been decided by the Constitutional Court include the LN and 21 others versus the Minister of Health case, which was a case about access to dialysis by patients who could not access the same at Kenyatta National Hospital. It is important for doctors to read also the decision of the court in the TB isolation case of Daniel Ngetich versus the Attorney General, whereby the courts held that in isolating TB patients, prison was the worst place to isolate them and mandated the Ministry of Health to come up with an isolation policy as well as isolate patients in hospital wards rather than in prisons. Lastly, it is important for doctors to note that decisions on the right to health are not made just by courts. In fact, one of the most prominent decisions that has been made on the right to health was made by the medical board in 2015 on the Alex Madaga case. This is a case that involved the right to access emergency medical treatment and the role of hospitals in doing so. It is also important for doctors to note that the HIV Tribunal has in recent years made prominent decisions on the right to health. This includes decisions that have been made by the tribunal on privacy, confidentiality, stigma and discrimination on the basis of HIV. All these boards and bodies, including the HIV Tribunal, the Medical Board, as well as courts, have made decisions that have been quite progressive on the right to health. It is therefore worth you noting that some of these decisions may affect parts of the work that you do as a doctor.